In today's lecture, we're going to be looking at Chapter 10 of the text, concerned with arrest and bail through arraignment, the beginning parts of the court process. Just looking to begin with, ways we measure crime, the crimes that we talk about. There are two major types of measures that we have for crime. First is based on official arrest statistics. That's the UCR, the Uniform Crime Report, which is produced by the FBI. It's a conglomeration of the information sent to them by various local and state police agencies. How many crimes were committed, of what type, in their jurisdiction over a period of the last year. They're trying to evolve that into what is known as NIBRS, which stands for the National Incident-Based Reporting System, basically just trying to get more information about the crimes that take place. We had already had that built in to the UCR with respect to homicides, collecting information about the offender, the victim, time of day, the reason why it took place, as opposed to most other felonies where we just record the frequency of them taking place. We're trying to evolve the UCR into NIBRS to have more information about the crimes that we find out about that come to the attention of law enforcement. The other type is the National Crime Victimization Survey, which is based on, it's a government survey that's conducted every year, where people are sampled, take a representative sample of the country, and then they're asked about the crime that was committed against them. And one of the major things that they ask is, did you report the crime to police? Sorry, that was my phone. I'm going to turn that off now. Because a lot of crimes, for a variety of reasons, aren't reported to the police. So what we're going to be talking about today are the crimes that get processed through the criminal justice system, so the ones that would show up in the UCR. But there is typically, depending on what crime it is, between a 10 to 30% gap in crimes that take place versus what's reported to the police. So the first step in the process leading to the trial is the arrest. Now, there are two types of arrests, two sort of levels of arrest. First is legal arrest. That's any time that you've been arrested by the government, and your constitutional rights thus apply. That could be in handcuffs. It could be in the back of a car. It could be standing on the side of the road or on a sidewalk with 4 police officers standing around you, and you don't feel free to leave. Basically, is the standard. The average person would not feel free to leave in that situation. That is a legal arrest, and all of your constitutional rights apply. Official arrest follows the formal reports and the formal account being taken, typically at a police station or at a jail, where the report is filed and then the case is referred to the court system. It's the difference between a legal arrest and an official arrest. The official arrest is more concrete, more, think of a good word or a good phrase, other than just more official. Official arrest is more formal. Again, mainly that there's a record being kept of what's happening. It's important to note when an arrest takes place, how an arrest takes place, the process for that happening. Police are very highly trained in when to and when not to arrest someone, and they know the standard of when an arrest takes place and when it doesn't. The difference between an official arrest and a formal official arrest and a legal arrest. Most people, lay members of society, wouldn't necessarily know the difference between a legal arrest and an official arrest, or even when your rights apply, or things like they don't have to read you a Miranda right or a Miranda warning unless they're going to question you. But the quality of the arrest is going to play a lot of important parts down the line through the court process, in terms of how evidence is collected, what things are going to be admitted into court and what things aren't. So the first actual court appearance is called the initial appearance. The purpose of this is to establish the identity of the person being charged, inform them of the charges that are currently being brought against them, inform them about their rights, right to counsel, and all that goes along with that process. establishing the location of where the trial is going to be held, what jurisdiction is applicable, does the person need to be extradited to another jurisdiction. Also, this could be either before or after, depending on if the person has an attorney or not, any type of police interrogation. There's also going to be establishment of bail. Potentially at this point, sometimes that process is delayed to later on if the judge hearing the initial case doesn't want to be the one to establish bail. In the federal system, we talked about that before. The federal magistrates are the ones that are hearing these initial appearances. They're not going to be the ones that are going to be hearing the trial, so they might defer the decision for bail to the actual trial judge. Typically, these are very quick. And the basis is just, is there probable cause to move the case along to the next step? The way that charges are brought, the formal charges are brought, so the initial appearance, there's going to be some review of what charges are being brought against the person, but that's not necessarily completely set in stone. Charges can change between the initial appearance and the start of the trial or a plea bargain process. So how the charges are actually formally brought that are going to be going to trial. In lower level cases, there's going to be just a complaint sworn out from witnesses, from police, depending on who witnessed a crime or how or when it took place. In some jurisdictions, do not rely on the grand jury process, which we'll talk about in a few minutes. The prosecutor issues what's called an information, which is basically a review of their cases. A review of their case that they present to a judge to establish is there probable cause to move the case forward. The most common type in felony cases is an indictment, which is where a prosecutor presents their case to a grand jury. The grand jury makes a determination of whether or not there is probable cause for a trial to take place. The old saying is that a grand jury will indict their own grandmother, meaning that the bar for seeking an indictment is fairly low, which makes it that much more troubling when you have some of these high-profile cases that we've seen recently, particularly the Breonna Taylor case, where the grand jury, the outcome of the grand jury proceedings was that serious charges were not brought. Those in the know understand that oftentimes it's just a formality that the prosecutor goes through the grand jury process to get the charges that they want to have brought at the trial phase. It's an example of the extremes of the prosecutor's power, more so in the information than the indictment, but they are fairly similar processes, and they typically have similar outcomes. But it is the prosecutor's decision whether or not to seek an indictment, whether or not to create the information and then present it to the judge. Additionally, how the police conducted their business, collection of evidence, the arrest itself, can impact this process, can impact what things the prosecutor can discuss, what information they have relative to the case, is sort of highlighted here. And that's, again, sort of complicates the relationship between police and prosecutors, that the prosecutor has to rely so heavily on the police to move the process along. Again, it makes it seem like they are or should be on the same team, but that's really not the way the system is set up. If bail has not already been set at the initial appearance, following an indictment, oftentimes bail can be set. It really just depends on what the charge is, what jurisdiction you're in. Some places, Washington, D.C., for example, Philadelphia is the same way, do not like to keep people in jail just because they can't pay a bail. So a lot of times those individuals in those jurisdictions that are charged with less serious offenses will simply be released, what's called released on their own recognizance or signature bond, where they just sign paperwork agreeing to show up for the scheduled trial date. It really just depends on what jurisdiction you're in. Some jurisdictions are still sort of sticking to the old ways of trying to keep people in there and even profiting off of the bail system, the bonding system, getting fees and things like that for it. The most common Bail is just putting up the cash, giving the money to the state to hold until the trial takes place, until the person shows up for trial. In lieu of cash, oftentimes people can offer what's called a property bond. Typically, that has to be 2 to 3 times the value of the bail that's set. And it's the same thing. The government basically, well, in the case of property, if the person doesn't show up for court, the government can then, after typically 90 days, seize the property that was put up. So that can be sort of bad news in some situations where someone doesn't show up for trial and then their family's land gets seized. There's also the signature bond, as I talked about before, being released on your own recognizance, which is basically no monetary value worth of guarantee that you're going to show up. But that's not really necessary. Most people are going to show up for court because the ramifications of not doing that are typically much worse than the penalties that you would face anyway. There's also the private bonding system where you pay a bonding agent typically 10 to 15% of the bail value that is paid to them. You do not get any of that money back, and they then guarantee the rest of the money. As far as failure to appear, in the case of the bonding agent, if you do not show up, that agency is basically on the hook for the full amount of your bail. They're going to send a bounty hunter after you. And when you sign that bonding agreement, you agree that if you don't show up and they send a bounty hunter after you and they bring you back, then you have to then pay that fee to the bounty hunter, which is again typically going to be 10 to 15% of the bail. So at that point, you've paid 20 to 30% of the initial bail, and you're not getting any of that money back. Additionally, if you put up a cash bond put up the cash bail or put up a property bond, you're going to lose that. You're going to forfeit that money or forfeit that property if the person doesn't show up for trial. Again, another reason why you can typically identify the people that are at high risk of not showing up for trial, and those are the people that potentially should be held in pretrial detention. One of the reasons they don't do that more often is because the conditions in jails are dangerous. It's worse than prisons because there's a lot more people coming in and out of there. There's a lot more opportunity for contraband to get in, for weapons to get in, for people to get sort of lost in the system. So jail conditions are very bad. Also, the delay in the trial process, as we've talked about before in this course, for a felony case could be 18 months, 2 years from when the initial appearance happens to the actual trial. So there are a lot of issues with the system right now in place, and what to do with individuals that are facing charges but not yet having their day in court is interesting. So be sure to watch the linked video about the bail system for this week. And the main company that they sort of lampoon in the video, a friend of mine actually worked for that company here in Gwinnett County. So it's very close to home. Georgia is at the forefront of a lot of shitty aspects of the criminal justice system. We have been slow to reform our system in a lot of ways, especially with having Atlanta being one of the major cities in this geographical area of the country, having that large dense population, in the metro area, Atlanta, DeKalb, Gwinnett, Cobb, Clayton County, Douglas County. We should be better at it than we are. So following the issuance of the indictment or the information, move to the preliminary hearing, which is where a judge is going to review that, just again to make sure that everything is proper and that there is enough information present, enough evidence gathered and has been presented to the court to meet that standard of probable cause to bind the case over for trial. Again, this happens in open court. You have the judge there. Both sides are present, which is quite different than what the process looks like in the grand jury. Again, the main aspect of this is to establish probable cause and bind the case over for trial, seeking the issuance of an indictment by the grand jury. These are closed proceedings. There's no judge. It's only the prosecutor and the grand jury presenting their case. There is opportunities for the prosecutor to present evidence that's been gathered by the police Also, this can be gathered by the prosecutors, investigators themselves. Oftentimes, large prosecutors' offices will have their own investigators um, to work on the things they specifically need, and because of the uh, to in part to help reduce the association between the police and and the prosecutor's office, the reliance on that. Um, it's again, it's important to keep those entities working in some aspects together, but to have them overall be separate entities in the criminal justice system. So larger prosecutors' offices are going to have their own investigators. There can also be witnesses that are required to come before the grand jury. They have that subpoena power, and frequently individuals are granted immunity with things that they would say if they're testifying against another individual. Much the same way they would receive that immunity at the trial process. Again, to try to present the grand jury with the information about the case with as much openness as possible. Many times individuals will receive immunity for the things that they may testify to relative to the criminal cases that they are testifying about. Again, following the issuance of an information or the issuance of an indictment, you're going to have an arraignment, which is basically the last beginning step before the trial process actually starts. This is where the formal charges that are listed in the information or the indictment are read, so the person knows finally what charges they're going to be facing at trial, and this is where a plea is typically entered to those charges. Most felony cases don't get past this point. 90 to 95% of felony cases in any given jurisdiction are going to end in a plea deal here, but there are some that move forward into the trial process, which is what we'll be talking about later in the semester. Looking here, this is just sort of an example of, not example, an illustration of sort of the frequency with which the cases that the trial courts see. The top is very highly celebrated cases, cases that receive a lot of media attention. Those are fairly few and far between. Not many of those cases are going to be heard in a given jurisdiction in a given year. Next is serious high-profile felonies, ones that maybe receive some media attention but not really that much. They're not going to be followed every day in the court by a lot of media coverage. Then you have the ordinary felonies, which are just basic everyday stuff that the courts are hearing. And then at the bottom is the misdemeanors, which is the vast majority of criminal cases that courts hear. So again, as you go down, there's less and less of those cases, and it's another instance where the fictitious media, even the news media coverage, sort of skews this. Because they only cover these few cases, you would think that that's the majority of what's coming down the line, or the way that these cases show up in having movies made about them, or being taken. In the original Law and Order show, something would happen, a trial would be taking place, and a month later they would have an episode about it. So there's sort of an over-reliance on those top two tiers in terms of what is brought to the general public's attention, but in reality, the vast majority of what the courts are actually hearing are the bottom two tiers, especially with the misdemeanors being the vast majority of the criminal cases that are brought before the court. Okay, so that's an overview of the beginning of the trial phase. We'll move along, now that we've covered all the actors in the court system, we'll move along later and look at the other steps in the process.